Hello, welcome everyone. Happy Thursday. We're almost there. Hopefully, it's cooled down a bit for you now as well. I know there were some crazy heat waves happening earlier this week, definitely for me over here in Rhode Island. But anyway, thank you for taking some time and joining us for Prep with Purpose: How to Build Better Trial Binders, presented by Paralegal Brief and sponsored by Steno. I'm Tara, the webinar manager of Paralegal Brief, and I am very excited to bring you this new session that's going to walk us through proven systems for crafting comprehensive trial notebooks and binders. I am really looking forward to hearing from Joe Stevens today and what I'm sure is going to be a really valuable and fun conversation, as always. And just so you know, we will be recording this webinar in case you have to leave early, and we'll be sending it to you by email within 48 hours. You can also visit the webinar's registration page where you signed up after today's session to view the recording there too. And as a reminder, NALA CLE credit approval has been granted for this program, and this program qualifies for one CLE credit hour under the non-substantive category as long as you are present for at least 50 minutes. That's 50. I'm going to send these notes in the chat for you to reference right now. Up next, before we go any further, I just want to thank Steno for sponsoring this webinar and helping us to make this happen. Steno offers exceptional court reporting services combined with best-in-class technology and deferred payment options. Steno was built by tech and legal experts who saw a need for a better experience. They remove financial and technical hurdles so you can focus on the case. From creating bespoke solutions for your technical needs to providing flexible financing, Steno is revolutionizing the way court reporting is done. And you can learn more at steno.com. So thank you again to Steno. Up next, other way. Thank you.
Great start.
We'll, we'll quickly go ahead and get some technical things out of the way here. Please don't hesitate to ask your questions as always during today's event. You can do so by submitting any questions into the Q&A panel found in the toolbar at the bottom of this webinar window. I don't want any important questions to get lost in the chat, so please use the Q&A if you do have any questions you want to address during our dedicated Q&A segment near the end of the hour. And as I kind of mentioned, the chat is, of course, open to share your comments and thoughts as we go along. Don't forget to change that blue button in the chat box to everyone so you can join the conversation there. You can also feel free to use the React feature to send an emoji and let us know what parts of the presentation are resonating with you. My wonderful colleague Tori is also in the chat and she'll be fielding questions and comments today. She'll also be happy to help you if anything technical comes up too. So feel free to pull up the chat or the Q&A and get familiar. I see a lot of people already in the chat. So yeah, let us know where you're joining from today. Also, closed captioning is available for this webinar, and to enable this feature, you can select the show captions option in the toolbar. And lastly, if you have any audio issues during today's presentation, you may choose to dial in by phone. All dial-in information can be found in your webinar confirmation email that you got from Zoom, and Tori can also relay it to you here in the chat at any point if you do need it. Up next, today, again, I'm very excited to hear from Joe Stevens. We've had him here with us a couple of times now, and it is always wonderful to learn more from him. Joe's diverse professional experience ranges from direct client representation to working 3 legislative sessions under 2 different committee chairmen in the Texas legislature. A graduate of the University of Texas School of Law, Joe combines his passion for legal technology with practical experience to help teams work more efficiently and is now teaching the next generation of legal professionals at Texas Tech University School of Law. So, with all of that out of the way, Joe, I'm going to pass everything over to you.
Thank you, as always, Tara. Two quick thanks, as always, before I start. One is obviously the Paralegal Brief. Continually impresses me how well done, organized, and structured and thoughtful these sessions are. And then a real thank you to everyone joining. I love speaking to paralegals, truly such an engaged audience. I'm always mesmerized by the chat, and I wish I could pay more attention to it throughout the time that we spend together. And I see a lot of my Texas people. I'm coming to you live from, I guess, my living room here in West Texas. Um, and it's always such a joy to be here with you. And I want to talk today about what we're doing here, like building a trial notebook, whatever that actually looks like for you. The trial prep and the work that goes in, so much time, so much thought goes into the work that you're doing. And what we're going to be doing here today is really, really, really diving into the nuts and bolts of how to use technology, organization, everything to prep your case fully. Trial prep, I talk to my students about this. I teach at the law school at Texas Tech, and I talk to my students. So few cases go to trial, but we always prep them as if they are. Every case is negotiated. So the skills that lead into a good trial prep are so transferable to other parts of case resolution as well. So even if you're not sitting here with an active trial docket, even if you're not sitting here with a case that is ready to go to trial, even if your firm, the lawyer that you work with, is not sort of heavy in the trial practice, maybe the opposite is true for some of you. Let's get involved into the nuts and bolts of this because this is going to really deep dive into your preparation in general. So, keep the chat engaged. I love it when I say something or someone has a question and everyone sort of chimes in with thoughts and tips. It really fosters this beautiful digital community that I think makes this group so special. There's always a question at the end about, resources and people who have have the experience chime in. I just love how supportive this group is. So we will save time for questions and answers at the end. Sometimes I talk fast. Court reporters don't like that. I try not to get super excited about this stuff, but it's really going to be hard because I'm going to start with this case that changed everything, and I can now talk about it because just last week it went public. Okay, so everything that we're about to do in the next up until the Q&A is something that I have done and did in some form or fashion in the work that I did on a case that just resolved with a large settlement. The settlement doesn't matter to me. That's not the reason I do this work. I didn't see a penny of that. But it was a case against the city of Chicago. And the city of Chicago, this man had spent 30 years, nearly 30 years in prison for a crime that he actually did not commit and had an innocent certificate saying as much. He subsequently then did turn around and file a civil suit against the city of Chicago because of the brutality he actually endured during certain times that he was engaging with police. That case now settled, and he is now going to the degree to which he can actually live comfortably, he actually will be able to do so. As everyone knows, the amount of work that goes into a resolution like that, especially on a case of this importance and magnitude where a human life is truly, truly, truly in the balance in a way that is different than a lot of cases that I work on day to day. It is incredible how I was able to let me rephrase that. What was incredible with the technology and the trial prep that I was able to deploy that saved time and created really, really, really quick resolution to this case in a way that even 2, 3 years ago was not happening. So that leads into the why. And the why is so critical to me. Like, why do you do what you do is something that I ask myself all the time. Maybe it's sort of like gets a little too philosophical, but purpose matters so tremendously to me. So if in this case I was working on trying to get compensation for a man who had spent 30 years incarcerated for a crime he didn't commit, had been sort of, had issues with the police department, the why was I wanted to sort of make sure that I could do the best job on the case as I could. And I imagine that you in your day to day have your own why. And I wonder what that is. Like, what is the purpose? What is the actual thing that gets you going and keeps you going? Now we're going to drill down even more. If whatever that purpose is, we're going to make it even better today because we're going to get the tools in your hands so that you can actually go about doing your job even more efficient. Okay, the reason that this matters now is that everyone knows discovery is just huge, right? The cases might not have changed substance wise. The causes of actions might feel very similar, but what we have is we have a massive amount of digital discovery that floats around. It flies around. In some areas, we have real rocket dockets. I have used to practice in an area in South Texas where there was an expectation that from first appearance to trial, it was, within weeks. And to get any sort of continuance or extension on that really took, it was a work. It was a project. I think a critical piece of this too is attention spans. I don't know. I would love to hear what people think of this. Um, but I am so conscious when I'm standing in front of a jury that very often they can look at me as the person that is separating them from their screen time. The ability to pay attention to detail is, I think, a little bit more sparse than it used to be. So we're dealing with just like such an evolving world where there's an immediacy of information and an incredible amount of documentation, a shorter attention span, a quicker maybe expectation within the courtrooms themselves. And then amidst all of that, there's an expectation that you do your job absolutely perfectly and that you're as prepared as you can be 100% of the time, all the time. Okay, that's a difficult, stressful environment in order to be to be operating in. So I guess the gauge of confidence here that I would really love from people is like when you think about the preparation that you have and the systems that you have in place, how much of them need attention? Like where are the areas that fall short? What are the things that you feel strong at? Or your skill set is really polished. What about the areas of weakness? Like what are the things that you really want to pay better attention to? Um, I think it's really okay. And I really encourage people to be extremely vulnerable about the areas where they do need help. Like that's a really wonderful admission. Especially in a community like this, I think you're surrounded by resources, and admitting that you don't know something or that you want to get better at something to me is such a beautiful sign of strength, and it's such a wonderful sign of growth. And that's what we're here to do today. That's a really long-winded setup for like let's jump right on in. Okay, in my opinion, when we talk about a trial notebook, or when I say trial notebook, I think everyone knows what I mean, of course. But like we're talking about the thing, the system, the mainframe, the binder, the digital binder that you have as you walk into a courtroom, and you are now ready to go. You and your team are ready to go. These are the three like absolute key features of it. How quickly can you access the information that you need? How intimately familiar are you with everything that exists in this binder? If it's overloaded with things that you might be useful but you're not familiar with, that's going to clutter up the ability to find what you need as quick as you'd like. Reliability, like how are you sure that the system you have in place is going to work? Are you flying by the seat of your pants with a brand new sort of, we're going to go digital this go around, but you haven't really kicked the tires on it? And then flexibility. We talk about this almost every single time I'm with y'all. My favorite feature in a reliable trial team, any trial partner, whether that's lawyer, legal assistant, paralegal, whoever is part of this trial team, is flexibility. The tiring part of trial, and I would love to hear anyone who sort of agrees with this, who has sort of sat through multiple trials and participated in them. If you can The fatiguing part is that it feels like every 30 seconds, every 20 seconds, you or someone on your team has to be making a decision amidst all you're paying attention to. Do I ask this question? Do I impeach this witness? How do I impeach this witness? Was this correct? Did he say this the right way? It's a nonstop series of decisions. So in a very fatiguing process, the ability to access what you're looking for quickly, make sure that you have a system in place that's reliable and then adaptable as well. The flexibility of it is so tremendous. So this is not to then tell you how to do things perfectly. This is to basically say, in my opinion, here are some guideposts and use these values to guide what it is that you're creating. And I think, and then personalize it, right? Some lawyers want certain things done certain ways, as we all know. But I think if you can really make decisions around fulfilling these three non negotiables, you're going to be in a great spot. Okay. Anatomy of a notebook. This is something that we're going to give you a template for, like you'll be able to download a little bit more substantive document on this. Here are 7. I was trying to really distill like what I have found to be most useful across the board in trial notebooks that I've prepared before I've stepped in a courtroom. And it really boils down to these categories. If anyone wants to chime in and sees something in here or would like to add something to this, I would love to hear about it in the chat. But basically, right, you have your case theory and your themes. this is like the value of the story of the trial. Like, are the things that we're doing in furtherance of the theme that we have and the theory that we have of this case? This isn't usually a big brainstorming session. This is usually something that happens months and weeks in advance as the case is just slowly building. And maybe you have a say in this. Maybe you're a voice in the room, and I hope you are, because very often lawyers can be way too close to the legalese of the actual case that they're working on. And it's a really beautiful thing to invite someone who might be thinking of this more like a jury to sort of talk about the importance or relevance or applicability or sort of reliability. What's the word I'm looking for? Um, of the theme, whether or not it hits home, whether or not it really feels authentic. Witness materials. This could be so many things. Um, Witness materials. It could be prior depositions. It could be a list of questions. It could be key areas that you're going to use to impeach. It could be anything pertaining to a witness, so that you know exactly what you're going to be doing with witnesses that you're crossing or witnesses that you're calling. Um, this is a large heading, but it's something that's obviously really relevant. If you have an understanding of how the case is going to flow and you know what you're trying to accomplish with each witness, then you can actually build this notebook accordingly. Evidence command. Amazing. Okay, so what evidence is going to be introduced? What evidence are we trying to exclude? How are we going to go about doing that? I don't know what your tasks might be on these cases, but sometimes it is as simple as having the relevant case law at the ready to object to something that the opposing party is trying to admit with a relevant citation to the rule of evidence, whatever it might be, and the argument that's going to be made. Legal authorities. This can be tying to evidence. This could be anything. Are they trying to authenticate a document that you think can't be admitted? Whatever legal authorities you might think you're going to be relying on. Maybe just having things at the ready in general when it comes to jury selection. Was there jurors appropriately excluded or not? I don't know. I mean, this is again, these are just the different categories that might be fuller or emptier depending on your case. Jury resources, daily plans, emergency protocols. This one sounds like an afterthought. The number of times that the little details around a trial that have no bearing actually on the trial itself can trip people up. Like, do we have a lunch plan? Is there a meeting room that we have in case we need to sort of convene during recess? What's the internet like? Like, have we kicked the tires on the technology in the courtroom? Um, the emergency protocol, it sounds like logistics, but when I see we have someone at Steno who's really a magician when it comes to organizing events, and he thinks and his team think of details that just don't ever cross my mind. Having everything down to the smallest detail allows you to go in and face the unpredictability brilliantly. So, this is the anatomy of a notebook. I would really love to see Dana, I just see the most recent thing in the chat. Information on the hotel, trial support, food vendors. That's exactly what I'm talking about. That's a great ad. You cannot overthink things. The only thing that I would say is everything in this notebook needs to be meaningful. It needs to be there for a reason. It doesn't need to be there just because you think it's a thing that will fluff up the notebook and give it substance. Everything is there for a purpose, and it should be immediately accessible, and you know what's in there, and et cetera, et cetera. A big way of stepping back and sort of putting an umbrella over this entire webinar is to say, if you could reduce this to a sentence, you might not always win the case, but you will always outwork and put yourself in the best position to win if you win on preparation. Nothing replaces the most prepared person in the room. Okay, so we'll kind of dive into this a little bit more substantively. I'm also going to obviously keep an eye on the time because I want to make sure that we get back into the Q&A at the end, which is one of my favorite parts of being with you all. But the guiding whole principle is obviously the idea of what the case is. What is the case about? The summary of the case. How are we going to go about presenting this to the jury? I love being a part of a team that workshops something that winds up feeling so simple and resonant in court because the amount of time and effort that it takes to get to that point of simplicity can sometimes be insane, right? It's like that quote, simplicity being the ultimate sophistication. The sophistication of the process is tremendous, but you get to a point where you can reduce the theme and the theory and the story of the case to one word or one sentence. And if it resonates authentically, it resonates authentically. That's the guidepost. That's like the value system of your case. And then I would also kind of push it even further. Like, if you can't really reduce it, if someone says to you, "What's this case about?" And if you're free to talk about it, and you say, "This is what it's about," if you find yourself struggling, then it needs more polish. It just needs a little bit more refinement. And I personally feel like, again, no matter what your role on the case is, if you're in a position where you are front and center to this case. You've been working on it forever, and you can't explain it because of the way that lawyers are sort of muddy. Then it might need some more refinement. I love, love, love keeping in the back of my mind the idea that whatever it is that we're doing as a team to prepare for trial, if we can get to a point of this really simplified response, this simplified analysis of what it's about, um, then your team is in a good spot. So, excuse me, when it comes to witness and it comes to the sort of understanding the witness, the flow of witnesses, this is one that I think tends to be a little bit more paralegal heavy too. When you're engaging with prior depositions, for example, you, we'll talk about this. The deposition itself might be really useful, but what is going to be really useful now, especially with the technology that we have available, is using the depositions, using any prior admissions, any transcripts, anything that they have, and using that in conjunction with technology for the deliberate purpose of getting the information quicker. Excuse me. So maybe you have a witness who's been deposed a couple of times. You can, instead of just having the depositions in there, you can use technology to create a detailed list along with like page and line citations to the deposition itself of where they contradict themselves on key issues that your team is going to cross-examine them on. Like, the purposeful now engagement with the depositions is something that I was used to doing early in my practice that would take forever. Now, this part of it takes a fraction of the time. You get so much more high quality responses. You can build a cross examination with a tech. You can do so many things. I'm actually going to show you a quick way of doing that as we move on through this. So it's not just theoretical, but this is a beautiful area where the trial notebook can be, I hate to use this, I don't want to use this too strongly, but like really weaponized. You can really take the substance of what each witness what you're trying to accomplish with each witness based on what they've said before, and you can really drill into the points that you think and your team thinks are going to matter the most in a trial setting, or even a contested hearing in advance of trial. I love what's going on in the chat here. Like, the trial schedule is a perfect part of the logistics of the calendar of witnesses. I mean, this is beautiful additions. Love it, love it, love it. Okay, then, I mean, call it what you will, but if you know and your team knows that there's a witness that is potentially going to be impeached on a certain area, a contradictory statement that they made, or you get the sense that maybe they might be impeached with a contradictory statement that they made, depending on how the cross-examination goes. Having this kind of goes in conjunction with the last slide, having those prior statements at the ready, having the sort of potential line of questioning if they get squirrely. These things are now, it used to take so much manual labor to get these things done. And again, the tech I'm going to show you here in a moment, it'll show you just how easily you can do this at the ready, and you can prepare for every single contingency in the time that it used to take you to prepare for one. It's incredible. To those of you that are already using AI for that purpose, amazing. But I can't wait to show you this in action. Exhibit management. This is one that I love having a slide for because it's so important. Um, and this is one where I really defer to people who have been there before, have their processes. Um, there's the only way that this is really being disrupted now is when it comes to exhibit management. If now all trials are obviously now in person, but exhibit management during depositions is now happening. There are different ways to do it virtually that I think can be really, really, really useful and powerful. We're talking here more about the trial side. So exhibit management hasn't really been tremendously disrupted. There is in-court technology. There's a lot of things that have changed, but I think that your systems here are your systems. I mean, whatever your best practices are, whatever everyone's most comfortable with, I think as long as you have a system in place. Where I think it really gets interesting is actually on the virtual deposition front. There are a number of platforms out there that allow you, for example, to upload exhibits in advance, annotate them digitally, obviously, have the different tools at the ready so that they can be annotated, become a part of the record, et cetera, et cetera. So exhibit management is definitely in flux in some way, shape, or form, but I think that we've seen technology in the courtroom when it's come to exhibits for a while now. So it's not something that is super unfamiliar to a lot of people. Excuse me. Okay. Evidence admission. I talk to my students about this all the time too. It's so interesting to me. Again, this is something that lawyers should be comfortable and just be part of their process. And I wonder if any of you have had any experience with younger attorneys who really get tripped up by this. I mean, laying a foundation, it's amazing to me how often you have a key piece of evidence that you're looking to use, introduce into evidence, and you see someone in court who doesn't really know how to lay the foundation. Again, usually this comes with a more junior attorney, but which is amazing because I love seeing a really seasoned paralegal with a junior attorney because the seasoned paralegal is just like the biggest mind in the room in this situation and such an incredible resource. But very often, sometimes, well, you see young lawyers and even more seasoned practitioners fumble with things as basic as this. I really think when you have a script for something that is so rote, um, like this, having it here just so that your practitioner can have a reference point in case someone objects to not laying a correct foundation. I think it's a really just a basic thing to have in there and something that if an attorney, it's just a nice value add. I'm seeing it, something in the chat about Travis County District Court. That's Austin, obviously. Having everything uploaded in exhibits in advance and no paper copies unless there's a tech issue. Where I practice, I feel like I'm kind of still in the Stone Age a little bit. So that is amazing to hear. But yeah, the technology is obviously making its way further and further into courthouses across the country. So, law library, these are great things too. I mean, how many jury instructions? I don't know how many of you have been tasked with getting the jury charge prepared, but that is a critical piece. This is one of the things. I actually am a co-author on the Texas pattern criminal jury charges in the state of Texas. So when we prep for trial, and again, I don't know how many of you in the chat resonate with this, one of the first things that we do well in advance is get the jury charge together or our version of the jury charge together because we like to then use that as a guidepost, another guidepost as we prep for trial as well. Having the jury charges in there at the ready, making sure that you obviously have a digital copy of them because that's the way things are going now, easily editable. Any key cases, as we talked about, but this is your sort of law library section. Any anticipated objections, common responses to those objections. If there's anything personal to your practice area, local rules, any relevant rulings that judge has made, any sort of binding holdings that might come up, whatever is a necessary addition to this law library, which I think is a nice way of calling it, this belongs in your binder as well. Legal research. This is incredible to me. Like having cases at the ready to present to a judge and opposing counsel, having them tabbed, having them highlighted. These are another critical things. Maybe you use them, maybe you don't. But there is a certain, as we all know, like jury trials and trials themselves. I would even argue contested hearings out where no juries present. If there is a command of the courtroom, it comes partially from all of the preparation and knowing exactly where things are. So even if you don't use them, if you have the cases at the ready, if you have a sense when it comes to a potential contested evidentiary issue, for example, how opposing counsel might argue the issue, and then you are at the ready with the information in this trial notebook so that the lawyer can actually make an argument, present the case law to the judge, and wait on the ruling itself. Like this is a really thorough build of a trial notebook, but it's something that bailed me out in one trial that I had in South Texas. I always say this, but I wish I could just sit here reading the chat because the things that you all add to this really enrich this presentation. Um, Again, this is knowing your audience. I mean, is there anything more critical than this? Like you could have the best story in the world that you think. You could have the best facts in the world in your mind. You could have the best witness. But if all of this is sort of unbridged because you don't know who your fact finder is and you don't know what the audience looks like and you don't pick a good jury or whatever it might be, then everything sort of falls by the wayside. So I love this slide, and because when I was thinking about this, I've thought about the different courtrooms where I've tried different cases and it has how critical it has been to the case that I've been working on to truly, truly, truly know exactly to the best that I can who it was in the room, what forces were at play. Um, Obviously, knowing the background of the judge, but when it comes to jury selection, I mean, people are using jury consultants now. Um, can be sometimes you get the juror lists days in advance and figuring out exactly who is who and what their tendencies might be based on social profile. Like, who knows? The amount of research that goes into incredible jury selection to me, and even understanding the tendencies of a judge. I just think this is invaluable. Does this belong in a trial notebook? I mean, from a judicial point of view, understanding who your judge is might not belong in there unless you're planning on using prior sort of statements that he or she has made, rulings that they've made. That might be relevant to the trial notebook. But when it comes to jury selection, absolutely. Knowing what questions to ask certain people about information they've disclosed on their questionnaires, the amount of research that goes into incredible juries. I mean, it's an art form in and of itself, but it is truly, truly, truly one of the things that I think, what people say, that jurors have their mind made up after opening statements. If that's true, then it only magnifies the importance of knowing your audience during jury selection. Bonnie has a great thing in the chat. Have separate jury profiles, binders slash notebooks. That's a great tip. I mean, why not, right? Like once the jury is selected, you want to sort of having that at the ready by itself. It's such a critical piece of the trial um, as well. Let's keep on rolling along here. Daily battle plans. Did someone mention this in the chat earlier about having the logistics, everything from the witness calendar to what's going on each day, who the witnesses are, which is the expert being called this day, or any witness is going to be taken out of order. What do we anticipate? When do we anticipate ending today? Having that at the ready eliminates the guesswork of how things are going to go throughout the day. Oh my goodness, I'm interrupting myself here because Mary just said a beautiful thing too. Having good relationships with the clerks is very important. Having a good relationship with people in the courtroom that are not the judge is just critical. I was just in court in a tiny little county in West Texas here this morning, and without my relationship with the other people in that courtroom, things just do not go as smoothly. So great point. Okay, let's get back on track. When things go wrong, I mean, things always go wrong. Like I love talking to my students about this. It's sort of like, okay, you've prepared everything, you're completely in control, you think you've got it all. Things are bound to go wrong. What you do in those moments is the time that your preparation is challenged the most, and it determines how strong like that preparation was. What happens when you get a ruling that you don't like? What happens when evidence pops up that you didn't anticipate? Again, the tech fails. A witness shows up. That's definitely happened to me before. I mean, how do you handle all of these things? If you are prepared, then you can handle all of these things. And it's all about relying on your skill set and relying on your team's skill set in the face of that uncertainty. And I love watching that. Here's some tech that you can use, right? Like this is just general. I don't have specific sort of products in here that I'm recommending, but I would love it. People can pop off in the chat about really wonderful technology that they use or that they find to be valuable. It happened at the last webinar where people were saying like, I use this for this and I use this, and I love that information sharing. So, um, if there's anything that people feel from a tech front that matters to them or that they use a lot that adds a great deal of value, I would love for people to chime in. We're coming up on the end of this. I'm going to pause here really quickly because I'm going to pop over and I'm going to stop sharing this screen and I'm going to come over to I want to show you just one version of something that you can use in anticipation. Like I was going back to the witness prep side of things. Okay, look, check this out. What we used to do, you're looking at a product here called Transcript Genius. I work for Steno. It's built by Steno, et cetera, et cetera. I'm not here to sort of do anything other than showcase the functionality of the product in a way that'll add value to your practice. What we have here is we have a deposition. Okay, when you're looking at trying to figure out now, okay, I've got to get this in place. One of my trial tasks is figuring out whether or not this witness contradicted themselves across the course of this transcript. Um, and maybe you have a specific thing that the lawyer that you're working with is looking for, or maybe the lawyer is just saying, I just remember um, so many times throughout this deposition where this witness contradicted themselves. This used to be, for me, an all-day task, maybe even longer. And now you've got, in this click of a button, you've got the transcript in a secure AI portal, and you're able to dive into it and just be able to take this answer on contradictions, copy and paste it into your clipboard. And right here, you have all of the actual reference points to the transcript itself. Like, when it comes to witness prep now, in my opinion, with the technology that's out there, there's no reason not to be super, super, super prepared. I'm going to do one more thing on this. It's amazing on one transcript. What about when you have two? What if you're sitting there and you ask it to uh, give me a timeline of events in table format? Maybe the issue in the case involves conflicting timelines. Maybe you're looking to really see exactly, who said what at what time, what took place at what time. Now we're using two transcripts to really distill a timeline of events in real time. The technology is out there now to support the preparation in a way that never existed before. And honestly, the younger practitioner in me wishes it was there. Again, you're seeing the citations in line. It's incredible value add. If anyone wants to sort of talk about this or technology more, I'd be happy to. Otherwise, let me get back to the actual presentation itself. Here we go. And here we go. So, sidebar survival kit. I'm actually not even going to get into this. I've got a couple of slides of really creative applications. I want to actually jump into questions here in a moment. This is when I say sidebar survival kit. What I was referring to was what a bunch of people have already talked about in the chat. Like, what I don't know. This is a really personal thing to where you're practicing, what case you're working on, what the local rules are as well. And I've loved seeing some of the local rules be sort of explored in the chat. These are the things that are like truly, truly, truly your survival kit. I don't know another way of putting it. I suppose that's why it's on the slide. But these are the extra details that get you even more and more and more prepared, based on what's going on in your case, with the people involved in your case, wherever it's being tried, and everything from, as we've talked about, like where the hotel is located in reference to how you're getting to the courthouse every day, what time you're meeting, to what judges prefer and how everything. I mean, that's your sort of catch-all survival guide. I've done this one before too, where I've known that this was going to be an issue in the case. So I'm using this as a specific example. The creative application here is there a specific thing that you anticipate to be true in this case that might not have been true in another case? I knew that, for example, one of the state's key witnesses in a case that I was trying tended to get easily flustered on the stand. And when that person got flustered on the stand, there was a tendency to say things that didn't line up necessarily with what that person had said before. So my anticipation here was not witness rehabilitation. It was quite the opposite. It was knowing that if this witness was pushed on certain things, there are prime opportunities for impeachment. Okay, now there was a section for this specific impeachment, the rules around it, and then holding them accountable with prior actual sworn testimony. And then jury questions as well. I mean, we could spend hours just talking about jury selection as it is, and I find it to be such I think it's the most, besides a really good cross-examination, I think watching a practitioner pick a jury in a way that's not boring and tedious, but it's actually thoroughly engaging. I don't know if there's a better way to set the table for a credibility win and sort of a fact win with your jurors than being sort of the most prepared, most reliable voice in that room. So any role that you have in jury selection, someone was talking earlier about having a specific sort of binder just on the jury selection side of things. And I think that's a great idea as well. Um, a broad slide here too. It talks about having clear roles be assigned. I think it's a really important thing. Clarity matters tremendously. And in the last paralegal brief, and it sort of comes up in every webinar, we have someone ask a question about, how do I, if I have ideas but they're being overlooked, or how do I assert myself more, or um, and it's a wonderful question with a really difficult answer because there's not really a solid answer. But the two that come to mind that sort of are pertinent to this slide, you know, lawyers can tend to be hierarchical people and can sometimes like to control everything. Sometimes they're very deferential and actually like to hand things off. Clarity in my office always matters to me. Who's doing what, who's responsible for what. But it really, in my mind, is ideal when it's a team approach, but someone needs to be making a decision. If you are playing a role in a team where you have ideas and they're not being listened to, you have a couple of I think solid approaches. One is to just deal with it if that's something that you want to do. But the other is no one's just going to sort of you've got to you have to empower your own voice, and sometimes that can come with a risk. And there are ways to do it more appropriately than others. But if you think that something needs attention that's not getting attention, if you think that something's being overlooked that shouldn't be, I think that as a valued part of a team, it's critical for you to raise that. And as I always start with every time I talk to paralegals, the role that you play is so unheralded, it's so underappreciated. And I wish that everyone could sort of step back and actually clap a little bit more loudly for the things that you do, because you very often are the most important person on this team and get a fraction of the credit that you deserve. Anyway, this is just sort of a soapbox I have about collaboration. Without it, I think everyone sort of falls apart, or and it becomes noticeable in a courtroom setting. A team that is functional and fluid in court, I think it plays beautifully to a jury and it plays beautifully to the outcome of your case. Here are some obvious common pitfalls. We talked about being over-organized. Over-organized also means being over-inclusive. You don't need to have everything in your trial binder. You need to have the things that matter in there. Making sure that you have systems in place in case things fail. We talked about that a few slides ago. Not training your team is one thing. Also making everyone needs to have a clear role. Who do we go to for what when things kind of fall apart? And then obviously making sure that you have things at the ready, readily accessible, going back to one of our earliest slides on this very point. So here you're going to get these slide decks so you can actually go into this. This is just a general structure and some suggestions of how to build out a sort of a schedule of putting it together. And knowing how to gauge success. One of my favorite questions to ask is like, what does success look like? Obviously, from a trial level, it could mean a certain verdict. But on a week by week level, it could mean just advancing the preparation and making sure that certain tasks are done and things are slowly being compiled as different members of the team are putting them together. Here's a little bit of a checklist that you can put, again, theoretical, something that you can use as a reference point if you like. And then we've got a quote to wrap things up before we get into questions. I believe this so wholeheartedly. I see the theatrical lawyer in the room thinking they're going to use their words to sway everyone all the time and doesn't have anything to lean. If you are prepared, if your team is prepared, it is just like gold. And I think it is fundamentally irreplaceable. And the work that you do to make that preparation a reality is always, always, always tremendous. So we'll go into Q&A now, I think. Let's do it.
Thank you so much, Joe. There are so many, great points that you hit and a lot of great tips in the chat as well. So before we do dive into our questions, I just want to state a reminder that, of course, if you need to run, we understand today's session is being recorded and will be emailed to you within the next 48 hours, along with the slides, the Anatomy of a Trial Notebook PDF that has been in the chat, and a copy of the webinar chat. I know a lot of you guys are really interested in going back and taking a look at some of the comments here. So Okay, with that, let's dive into some questions. Um, an interesting question coming in from Lori. Um, is there any key differences between contents and structure for bench trials versus jury trials?
Great question. And yes, I mean, obviously the jury side of that then falls off. Your audience becomes a much more known entity because it's a single person, it's a judge. So a lot of the noise of the early sort of prep can just be tailored to that audience. You can really hone in on, decisions that person has made in advance. If you've practiced in front of them before, what their tendencies are, what rulings they've made. Um, the theatrics kind of change, right? I mean, you're not having to deal with a jury, so it can be much more to the point. Usually, a bench trial is going to entail some sort of really specific legal argument that you'd prefer a judge to pay attention to rather than a jury. So, a lot of the development in that area is going to be making sure that the technical legal arguments you're making are going to be really, really, really clear and supportable. The other thing, this also exists in a jury trial, but it might be more relevant in a bench trial because of the technical side of an argument there, is having cases at the ready in support of the argument that you're making. So yes, I would just say that the emphasis then becomes much more on the single fact finder there rather than worrying, of course, about anything related to jury selection, which is a huge time save. Great question.
Thank you, Joe. Moving right along here, we have a great question coming in from Anonymous. And I've seen this kind of floating in a couple of different ways here, but really, if trial prep time is incredibly limited, what would you say would be the most critical to complete?
Oof. I love it. Okay, I used to, as a public defender, I mean, I still run a public defender office where I had a huge caseload and sometimes not much time to prepare. Um, One category is know your audience. Again, bench trial or jury trial. You cannot, if you can't uh, underprepare your voir dire, your jury selection. I think I said that in a very Texas way, but you can't underprepare that front. That's critical. I would then drill into so the audience side of it matters the most. You've got to still have a solid theme and theory for the case, and that involves understanding the flow of witnesses too. I would not skip out on anything related to the core of the case, theme theory, and knowing your audience, and then being able understanding exactly what is going to be like what the witnesses are being used for and how to then cross-examine them if that's the role that you're playing. So everything else, quite frankly, like if you have to save time, depending on the skill set of the practice, having a really comprehensive opening statement might be an area where I would trim it down, quite frankly. Like you can have a very compelling opening statement without going into a tremendous amount of detail. Closing is the same. I mean, if there's a good speaker, if the lawyer is a good speaker, that's something that you can. I'm not saying it's not important. I'm just saying if you have to sort of save time somewhere, it would probably be on that front. You can't compromise on understanding the nuts and bolts of the case, though. If you do that, then you look unprepared, and your team doesn't look good in courtroom. So that's where I would probably save some time.
Thanks, Joe. And if
Mm.
there's any, follow-ups or other things to add, feel free to share those in the chat as well. Um, okay, our next question, coming from Cindy, any suggestions on pre-trial notebook tracking?
Ooh. Um, I'm wondering if I fully understand this question. Um, Pretrial notebook tracking. I'm wondering if this is sort of like you have different assignments across different parts of your team, or if you are tasked with the creation of this entire thing, how to actually track the development of it. I don't know if either of those are actually your question, though. Um,
Joe,
track,
yeah, so Cindy did clarify a little bit, tracking the pleading, filing, etc., across the team depth.
yeah, I mean, the only advice I have on that front is that I do two things. One is I sit down with the team in person when I'm sort of orchestrating it, and I make sure that we have a list of assignments and that everyone who is going to receive an assignment or might receive an assignment is in the room and briefed on it in person. And then I actually use just a work management tool internally. I mean, it's kind of like a version of Asana, which is one technology tool that's really used for big teams collaborating on projects. The premise is very much similar. I will actually put deadlines in there with assignments pegged to specific people. And I expect, as a part of that briefing, that as they're going through and completing these tasks, that they update me and they can mark them as complete, or they give me a reason as to why things are taking a little. That way, it's all central. Everyone has a line of sight into it, and the expectations are clear from the outset, and then they're tracked all the way through. That's the way it works for me. Other than that, I'm sure that you could probably personalize that system a little bit, but that's the one that I think feels like it works well. And I'm seeing some suggestions in the chat too. Microsoft lists, Gantt chart, obviously things like that.
Yeah, amazing. Thank you, Joe, and thank you all
Mm.
for sharing in the chat too. Our next question is coming in from Christine, who says she recently began using Transcript Genius and it's such a time saver. Her question is, they use Steno for depo of opposing parties or witnesses we call, but opposing counsel always picks the court reporting agency for the depo of our client. Can we upload our client's depo to compare to the opposing party's depo?
Yes, absolutely. And I know that I forget the name of the person who asked this question, but feel free to reach out to me directly and I will show you exactly how to do that. 100%.
Thanks. And yeah, Joe's email and LinkedIn are not only on screen, but they are also clickable in the chat as well. I think you may just have to scroll up for a second. Okay. Next question coming in from, let's see, oh, Anonymous. Have you seen an uptick in folks using electronic versions of trial notebooks versus three-ring binders and folders? Is there, software that does this, or are most people still sticking with the traditional?
I love this question. I mean, I live and practice in a place where technology is a little bit more scarce. So I see a lot of traditional. I think it's practitioner by practitioner. I'm sure that there's probably a number of you hearing that question now, thinking of a practitioner who is still hanging on to the three-ring binder and old ways of doing things when there's way better tech solutions. Um, but I am seeing it. Absolutely. Never before in my time practicing have we seen an influx of technology that is allowing people to be better prepared way quicker and doing it in a much more thorough way. Like, no, when you open Microsoft Word 20 years ago, even now, it was never able to sort of draft a pleading for you. Now you can go in and you can have AI really do things like that for you. So the tech is there. The adoption rate is more rapid, in my opinion. And for people who aren't using it, I would encourage you to either reach out to me. We can talk about ways you can, but it's there. It's a time saver, and I just don't know how people are practicing without fully leaning into it right now.
Thank you. Looks like we have time for maybe a couple more questions here. I see a question coming in from Amy, um, who is a little bit more broad, more general, but especially when it comes to trial prep, and notebook prep, how can you prevent burnout from all of this work? Any tips?
You know, it's so funny how this question comes up, and I love that it keeps coming up because it suggests something that we all know to be true, which is this work is really hard. Like it just is. And the work that you do is doubly hard because of what you're doing. And quite frankly, it was something I was saying before, how very often it can be just, you must feel like it's taken for granted. Those two things conspire to create what you're just talking about, like the burnout side of things. It's so real. And there's a number of ways to address it, right? Like how do you take time for yourself? What things are you doing outside of work? Do you have the flexibility to do that? How are you prioritizing that? Are you working in a place that fosters, self-care? It's all so critical. I don't know what your specific approach can be or what the ideal outcome is. It's probably something in the list of things that I just said. Like, how do you truly turn off? Can you put your phone away after work and it be okay? Is the expectation that you're working over the weekend? Like, all of these things need to be answered on a personal level. But I would also reaffirm in my answer that what you're feeling is real. It shouldn't be the norm. You shouldn't be teetering on the brink of collapse. That's not healthy. You shouldn't be working in a place, ideally, that is overlooking that and treating you as a commodity, if indeed that is the case. And I'm not saying that that is for sure. But the way you are as a person, like if your cup is empty as a person, how can you provide and do this work in any sort of meaningful way? You are going to get burned out. And when you get burned out, it's really hard to refill that cup. So if you're teetering on that edge right now, I would try and think of one or two things that you can do. And even if that means a conversation with someone in your office about taking some time, or if you can turn a 2-day weekend into a 3-day weekend, or because the work is done. I mean, do it. I just don't know another way. And I really hope that workplaces, as tech evolves, as things continue to evolve, I really hope that they understand the magnitude of making sure that the people that are doing the best work for them and everyone in their office is truly, truly, truly taken care of, because that's what matters most.
Thank you, Joe. Yes, we absolutely do see that question coming up all the time, and I think we can all kind of relate to feeling that way. And it's great to know. I mean, clearly in the chat as well, you're not alone, and you will never be alone in that. So, okay. And this last question I want to take comes from Rihanna. What is the worst thing a paralegal could do during trial prep and notebook prep?
Oh, we should do a session on this, like an opposite day session on this. The worst thing. I mean, goodness, there's so many things that fall into this category. Leave holes in it. Like don't have all of the things in one place. Wait till the last minute. Um, be frantic when things get hard because things have been left out. Uh, have the wrong information in the wrong places. Not have things sortable and easily accessible. you know, it's amazing. There's so many things. I suppose the opposite of everything that we talked about in this is probably true. So don't be that person is what I would say. And if there's specific things that you're thinking about, let's talk and we can make sure that you don't do those things.
Yeah, and I love the comments in the chat. The worst thing you could do maybe is run out of the room.
Yeah,
And
this is
Patricia
true.
makes a good point to check laptops for any software updates prior to trial. That has gotten me more times than I care to admit. Um,
Yeah,
so
it's very true. It's very true. Although sometimes you can pivot those moments into really human moments too. I mean, it could be frustrating if you have a 3 hour down upload, but if it's a 20-second pause, everyone's sort of you can sometimes create a little solidarity around that.
Absolutely. Thank you so much, Joe. And with that, that is all the time we have for today. I hope you all took away half as much as I did. Before we go, I just encourage you all to participate in the quick survey that will pop up in your browser once this webinar closes. We take all of your feedback into consideration and we use it to guide the topics for our next sessions. So I thank you in advance. Thanks again to our sponsors, Steno. Joe, a big special thank you to you again for taking the time to answer our questions here and really provide us with so much valuable information today. Thank you.
Of course, thank you, Tara. Thank you to Paralegal Brief, and thank you to everyone who is so engaged. I always enjoy it.
Absolutely. A huge thank you to all of you for attending. Keep your eye out for a follow-up email with all of the materials we talked about today. Again, my name is Tara, and I hope you have a great rest of your day, an easy Friday, and a great weekend. Take care.